from the garage. It got 4 new tires on it, so Errol should be happy.
At one point, I think I had done 12 of these straight.
Really?
Wow. 2000. Streak ended in like 2017 or something like that.
Okay, we're going to go ahead and get started. Our next session is public works contracting. In other words, how to hire your brother-in-law to do the asphalt work. And it will be presented by Joe Lauber with Lauber Municipal Law. Joe established Lauber Municipal Law LLC in 2010 and practices in the areas of general municipal law, public facility, infrastructure, construction and financing, economic development law, public works contracts, annexation, land use planning and zoning, and appellate law. Prior to forming Lauber Municipal Law, Joe was an attorney with a boutique municipal law firm. That sounds very bougie, doesn't it? A boutique law firm located in Lee Summit. Before that, Joe worked at the region's busiest municipal bond law firm, where his practice was focused exclusively on economic development law. No note here whether that was Dewey, Cheatham and Howe, or what the name of that? Okay, very good. Thank you. He worked underneath Huey with the Dewey, Cheatham and Howe firm. While attending law school, Joe also worked as a law clerk at the city of Lee Summit, Missouri. Joe resides in Lee Summit with his wife, Sherry, and their 2 children. Please join me in welcoming Joe.
Thank you, Chuck, I think. Well, thanks everybody for hanging around, and sorry, I'm going to grab my notes here and my glasses. Appreciate everybody, first of all, for taking time out to actually come and do this this training. I think it's important, especially for our newly elected officials, to kind of have a good baseline and learn, you know, some of the kind of red flag moments, if you will, kind of things to be aware of as you go through and try to conduct your business in whatever elected official or maybe appointed official role that you're in. I'd also like to just thank you all for, you know, taking the effort, taking the time in times that, you know, it seems like there's so much apathy out there that you cared enough to actually, you know, run for office and do something. And so we hope that you are very successful in what it is you're trying to accomplish, and hopefully you'll pick up some great resources through these couple of days of training, where you will learn, you know, kind of the best ways to get accomplished what you want. So, you know, they make us turn our presentation materials in a couple weeks early, and for some reason I seem to think that I was speaking tomorrow morning. So it is not June 11th, it's June 10th, just for the record. And thank goodness I checked that, because I would have been really embarrassed when I showed up tomorrow morning and they would have said, well, where were you yesterday? So let's see, before I get started, that actually I gave them a bio, but that was one from a while back. I was telling Chuck as we were getting ready to start here, I said, at one point, I believe I actually spoke at this conference 12 years consecutively at some point. But I've been doing municipal law now for 18 years. 10 of that I've been doing with my firm, Lauber Municipal Law, and we have 7 attorneys who do nothing but practice municipal law. We represent 53 Missouri cities as their city attorney, and 14 cities as prosecutor, and several dozen cities as special counsel for various matters, from economic development to, you know, just kind of helping out on something that's a little bit much for the regular city attorney to handle. So we appreciate our relationship with MML and the fact that they invited me to come back and speak to you all today. So the topic today for my presentation is public works contracts. At a fundamental level, it's important to understand how contracts work because it's different for public entities than it is for private. So if you're in a business and you're used to doing contracts, there's going to be a lot of elements that are the same, but there are some things that are remarkably different between public contracts and private contracts. And I pick on public contracts, public works contracts, because they have the most unbelievable details that kind of have to go into them. So if you get good at doing a public works contract, everything else is easy, maybe with the exception of, and I saw Alexa Barton earlier, we've done, those 50-page TIF economic development contracts together. And those are a whole different animal. So I'll save those for a different presentation. So with that little bit of a, find my remote here. With that little bit of a introduction, let's talk a little bit about what we're going to cover in our 50 minutes here today. So you see here on the screen, we're going to talk about bidding. We're going to talk about different delivery methods for public works contracts. We're going to talk about bonding, and we're not talking about general obligation bonds in this circumstance. We're actually looking at the types of bonds that will kind of provide protection for you financially with respect to if something goes wrong on a project. We're going to talk about prevailing wages, prompt pay, condemnation when you have to take property in order to get a job done, the Missouri laborers requirement, and some of the e-verify affidavits and immigration law requirements that came in effect about 13 years ago. So cover all of those. All right, so diving into the subject of competitive bidding. So you have on the screen here statutory requirements, but the first thing, and something I really want you to take away from this with respect to bidding is, please understand that at this time, currently, there is no single statewide statute that requires local governments to do competitive bidding, okay? That's a question I get regularly, where if someone calls up and says, do I have to bid this? Do I have to bid this? And the answer to that question does not come from state statute. The answer from that question comes from your ordinances, which we'll cover in a little more detail, okay? So while there's no general statute that requires kind of, on a blanket standpoint, bidding for public works contracts, depending on the type of governmental or quasi-governmental entity you're dealing with, there could be a statute that applies. Another thing that could cause competitive bidding to be fired up is, how are you getting your financing? You might, if you're using federal money, you might have a bidding requirement, or state money, and it's not just your own. So on the screen, what you see is several examples of projects that do require competitive bidding, but again, those are the exceptions to the general rule, which is you don't have a requirement to competitively bid except for what you have in your ordinances. I will note that this past legislative session that just ended a couple of weeks ago had Senate Bill 153. And in that, if you have a community that has a community improvement district in it, a CID in it, there is going to be a new subsection in that says that any CID public improvement projects more than $5,000 will have to be noticed and competitively bid. So that will be a new, very specific, again, project requirement for bidding only when a CID is looking to do projects. So just to keep in mind on that. Another note I would like to make with respect to the general thoughts on competitive bidding is in 2018, as we're going to learn here in a little while, there were some massive changes to the prevailing wage law in Missouri. And in that law, there was a small subsection in one of the statutes where it says that public bodies are exempt from any law requiring the use of competitive bids where the engineer's estimate or bid accepted by the public body is $10,000 or less. I'll tell you, I'm not sure if I think that's good policy, because we're going to talk in a few minutes about, depending on the size of the local government body, whether you need to bid or not, kind of matters, and how much that might affect your actual budget. So, my question, when that says exempt from any law requiring competitive bidding, Does that even mean your own ordinances? So if you as a city choose that, to do competitive bidding, now is the state telling you can't? I will advise my clients, I do advise my clients, if you want to competitively bid, do it. It's good public policy. It's the way you get the best price. And I don't know, how the state would, I don't know, they're not going to be able to fine you or something like that, and I think if, anybody got challenged legally because they went to competitive bidding, I think it would be a hard argument to make in front of the judge to say, nah, judge, it was really in everybody's best interest not to get the best price. So, all right. So, and right to that point that I was making, what you have on the screen in front of you now is a series of different size cities and what their requirements have been. And so you have the city of Lawson, Missouri, which is kind of the north part. I apologize, I'm fighting the tail end of a cold, so I'm gonna get choked up a little bit. Excuse me. Okay. So the city of Lawson is about 5,000 people, and their budget is somewhat smaller. And so they have, I'm so sorry. They have competitive bidding applies when a project is $2,000 or more. But you take a look at Kansas City, for example, with $1 billion budget, their competitive bidding starts at $100,000. So you can see why it's important for cities to have their own control, over the amount of money that they require for the bidding. I was worried that this was going to happen. I apologize. Okay, so we'll try to get past this rough spot in my throat here. Okay. Okay. So when competitive bidding is a requirement, what I will tell you is it is a good idea to require bid bonds. And so what is a bid bond? Bid bonds are guarantees that a bidder will honor the bid that they've submitted and that they will enter into a contract with the owner. Excuse me. In this situation, the owner, who would be the city. There are no general statutory requirements for bid bonds. Thank you so much. I've got one up here, but I'm having a hard time fighting it. Thank you. So there are no general statutory requirements for bid bonds for public works projects, but again, there are some specific ones, so you have to be kind of aware of those. Bid bonds may be required by local ordinance or policy. And again, it's kind of one of those good idea things, especially, excuse me, when you have a project where the bidding is on a project that's time sensitive. So we don't have, a super long construction season in Missouri. We're kind of middle of the road, but if you're sitting there kind of throughout the winter, planning your summertime public works projects, and you're going to bid that in February so that you can award it in March and start construction in April. The last thing you want to do is find out in April that your contractor that provided the best bid all of a sudden says, you know what, I can't do that after all. I'm not going to be able to do that. So because at that point, if you had to go out and rebid that, oh, you are a saint. Thank you so much. I appreciate it. Whew. Man, that's right. Yeah, I'll take that for sure. Dang, I am so sorry, guys. This is awful. All right. Oh, did somebody say it's in the trunk? In the truck. All right. Bourbon's on. I won't point out. All right. Hopefully this will get better. I apologize. Okay. So so it's a good idea to have those bid bonds, because if your contractor does not decide to enter into the contract with you, you're in a bad spot. And those bid bonds will actually make it so that you can get another contractor in there to fulfill without having to restart the project and kind of go from there. I'm so sorry. Okay.
So bid selection, talk about bidding there. So Missouri courts have been actually pretty friendly to cities with respect to their discretion in selecting bidders. And so you have very broad discretion in selecting the lowest and best bidder. But I will say, be very careful when you're making your bid invitations to say that you are selecting the lowest and best bidder, okay? And it matters, right? So the next time you're on one of those big high-rise bridges that goes way out over some water, think about for just a second, was this designed by the lowest bidder? Was this built by the lowest bidder? You know, sometimes lowest doesn't, it definitely doesn't mean best, right? So think about that. And the reason is that there are some contractors that just don't know what the heck they're doing. And so they'll underbid something because either it's poor quality or they, inexperience or whatever. And so lowest doesn't always mean best. One thing to keep in mind is bid invitations are merely an invitation to submit proposals to contract, okay? And so what that means is when you accept a bid, you have not entered into a contract at that point, okay? You have agreed with a party that you've decided that you're going to enter in, you are going to enter into a contract, but just by accepting the bid, you have not entered into a contract. I have a lot of folks who get confused about that piece of it. So definitely keep that in mind. Cities generally can reject all bids, any and all bids, and even the lowest bid can be rejected. Again, always try to be careful to put that kind of information in your bid invitation packet. Sometimes you'll run through the process and even all the bids that come back aren't even close to what your budget was for a project. And you need to be able to extricate yourself from that situation. All right, so let's talk a little bit more about lowest responsible qualified bidder and lowest and best bidder. So as I mentioned before, Missouri courts have been pretty friendly to cities with respect to their discretion on that. And there's actually a case that is a very prominent case with respect to the issue of selecting a lowest and best bidder. And that is Cat Excavation versus the city of Belton. So that is the case that says that public bodies have wide discretion to choose. And it says as long as the elected body or the government, the city, whichever, it could be the Public Works Department, or it could be the Board of Aldermen, or, depending on what level makes the decision, as long as you act honestly and in good faith, the court will not interfere with your decision in selecting a bidder. Okay, you have to follow your own process. If a bidder is going to be successful in challenging your award to someone else, it's usually going to be because you didn't follow your own process or there was some sort of wrongdoing involved. So you have to be careful with that and don't do that. Best bids are determined by several factors and elements, and the things that the courts, have said are okay for cities to look at are the honesty and integrity of the contractor, the skill and business judgment of the contractor, their experience and facilities for carrying out the contract, their previous conduct under contracts, and importantly, their quality of previous work for the body or other references, okay? And that's where I would like to make the point that it's fantastic that MML holds events like this where all of you can be together in this circumstance. You have the opportunity to network with each other and talk with each other. You all are here because you're doing essentially the same job. You're not doing it in the same place, but you all have the same issues over and over. We represent 53 cities. Okay, there's about 10 issues that cities have. No, I'm just kidding, but you are all dealing with a lot of the same things. So it's a great opportunity to meet people, maybe from your area or the same size of city that you are in a different part of the state or wherever the case may be. And you should talk to each other, okay? If you're going out to bid and you've got a huge public works project and you're concerned because you've never met this contractor before and you find out that a city, a county away dealt with them, pick up the phone and call them. And you're allowed to use that city's experience with that contractor and whether to decide to select this one. So, one of the main reasons I think, these types of events that MML put on are just really fantastic. So you have that opportunity to share with each other. Bid rejection. So there are 3 reasons for bid rejection. Bids are non-responsive, bidder is not responsible, or that the owner rejects all bids and solicits new bids. So what I will say is a rejected bidder has no vested or protectable interest in the award of a public works contract. So essentially, as long, again, as you have followed your own rules and you haven't done anything shady in the process, you're going to win pretty much whenever someone who didn't get the bid wants to challenge you. Okay. If you have a material variance in a bid, then that bid must be rejected. Okay. So if you're saying we want 3 new plastic orange slides for our parks, and a bidder says, well, I can't get the orange, but I can do the yellow. And they submit 3 new plastic yellow slides. Maybe you're, Oak Grove where their color is orange and black, and you needed those orange and the yellow just doesn't work for you. So, that's a material variance in the bid. So you have to reject that. Okay. Now, if there are minor variances in the bids, then those can be corrected, but material variances definitely should, must be rejected. And that's products that are different than those specified in your bid, proposals that change or delete any of the contract terms or conditions, or any proposals that contain a conditional offer, are all reasons that you can reject bids. Okay, thought I was through that coughing. Might be coming back, who knows. The next thing we want to talk about is the basic authority for contracting. So we talked a little bit before is, if you accept an invitation for a bid, that doesn't create the contract, right? It creates the relationship where you then negotiate the contract. In order to have a contract for municipal entities, you have to have certain characteristics, okay? First of all, your contracts have to be within the scope of the municipality's authority, okay? So you cannot enter into a contract to invade China, okay? That's not your business as a local government entity in the state of Missouri, okay? Nice try. When you do a contract, it must be made upon consideration that is wholly performed after the making of the contract, okay? So that's a situation where you cannot have, Jim Bob, just got his mower fixed and he went and mowed the park. He swings by City Hall on his way there and he says, oh, hey, by the way, I just mowed the park. Now you owe me $50. Well, no, you already did the work. Thanks for your donation. Okay. Can't do a contract for something that's already been done. Okay. All municipal contracts must be in writing and dated when made. There is no such thing as there's no such thing as a verbal contract with cities. Okay, so if your mayor is sitting at the bar and tells somebody that hey, you've got our trash bid for the next 30 years or whatever, and they just just have a conversation, that's not happening that way. Okay, and then finally, all municipal contracts have to be subscribed by the parties or their authorized agents. Okay, the other thing I would say is, going back up to scope of municipalities' powers, is the mayor, depending on what your ordinance says, the mayor may not have the authority to bind the city to a contract. In fact, in many cases, depending on the level of the contract, it might require Board of Aldermen or City Council approval. Okay, so I had a situation a couple of weeks ago where a mayor had told somebody, told a citizen that they could have a tree removed, and the tree got removed, and the contractor brought the bill by City Hall. And everybody at City Hall was like, what? And so, the legal answer to that was, I told them, is like, you guys don't have to pay that bill. I mean, that's, there was no written contract. The work's already been done. You don't have to pay it. Now, out of a policy decision, they decided to pay it, but that was, their choice. But legally, you do not have to pay that. And the other thing I will tell you is, if you enter into a contract with a contractor and you have your terms that are set, and then the contractor starts to go beyond the terms and then demands extra money, you don't have to pay that. I had a client, a pretty significant client several years ago that did a downtown beautification project. And in their circumstance, the project was set up for, I don't know, $1.2 million or something like that for this beautification project. And the contractor ended up overspending that by $600,000. No change orders, okay? Just submitted the bill to the city. And on that one, they called me and we took a look at it and I said, look, no change orders, right? And I said, nope. And I said, there's no amendment to this contract, right? Nope. I said, then you tell them, too bad. And they said, well, I'll get my lawyer. I said, okay, if I had a nickel for every time I heard that, I'd be a nickel millionaire. But what they ended up doing is they sued the city. Guess what? City won. So, again, if you don't have it in writing, and that contract isn't set, you don't have to pay it. And courts are very unsympathetic to people who don't understand those rules. And in fact, the court cases say that anybody who contracts with a city is charged with the knowledge. It's kind of like ignorance of the law is no excuse. You are charged with the knowledge that cities are very limited in their ability to enter into contracts. Okay, errors on bids. I'm gonna kind of cover this lightly because we didn't start my clock actually, so keep an eye on this. So, excuse me. So a couple things I want to just cover here is if the bids go out and there was a mistake, you treat it differently depending on how the mistake was made. So if a mistake is unilateral, so it's on one side of the party, and then if there's only relief from the mistake if it's clerical, okay? So the idea is you put out a bid, excuse me, for street resurfacing, and the individual submits a bid, it comes back, and that, you can tell right away that bid is, 100% cheaper than everybody else's bid out there. And you can pretty much see by looking at the other bids that it was clearly just a decimal place. Okay, like they got their decimal place, in the wrong. So it's what we call sometimes a Scrivener's error, okay, or a clerical error, right? So if the mistake was just on the party submitting the bid and it was a clerical error, then you give them relief, right? So you don't make them do the project for pennies on the dollar and take advantage of them, okay? So it's just common sense from that standpoint. If a mistake is mutual, so both parties didn't understand something, then the contract itself can be rescinded. So sometimes it's the reason that you see rock clauses in contracts that involve excavation, for example. But if you don't have a rock clause in there and you didn't know the rock was there, a lot of times that's a mutual mistake where you didn't cover it in the contract, nobody knew it was there, and then you get through to it and you say, okay, look, neither side understood that there was rock here. We both made a mistake. At that point, you can rescind the contract or you can actually renegotiate. So a couple places there I just want to kind of cover, in case those things come up for you. Bid protests, again, I'm not going to cover this in very much detail, but I said it earlier, I'll just say it again. Courts are not very friendly to people who protest bids. And so, and in fact, what courts have said is disappointed bidders. So people who are, who I call them jilted lovers, disappointed bidders actually do not even have standing to challenge the award of a bid. So you can actually get that case booted right off the bat and have it dismissed. Okay. If you're doing bidding, one place that there is a very special rule, so this should be like a red flag moment for you, is if you are bidding professional services, very specific professional services. So what we're talking about is architect, engineering, or land surveying services. If you're looking for any of those three types of professional services, there is a very specific statutory process for getting those folks. Okay, and the what I will tell you is, so it's actually covered in Chapter 8 of the Missouri statutes. It's 8.285 to 8.291, and it's modeled off of the 1972, if you've done any federal work, you may have heard of the Brooks Act. Okay, so this is essentially what we call the mini Brooks Act for Missouri. And it basically says that when you go to hire these types of professionals, you do not do an RFP, right? A request for proposals, but instead you do a request in an RFQ, a request for qualification. So all of your selection processes for these 3 types of professional services must be qualifications based only. You cannot talk money with these professionals until you have first gone through a process, and the statutes are very detailed on this, but essentially what you do is you get all your bids or your proposals in, I'm sorry, I keep saying the wrong word. You get all your qualifications in from the possible contractors. You pick the top 3 that meet your needs, and then you start a negotiation with number 1. And if you can strike a deal with number 1, sweet, you're done. If you can't strike a deal with number 1, then you're allowed to move to number 2. And if you can't, get a deal done with them, like they're too expensive, then you can go to number 3. And then basically what the statute says, if you get through all 3 of your top 3 and you still can't land on a price, you can't agree at the cost of the services, then you have to go back through the process again. So, but red flag moment for you is if you're hiring any of those types of services, take a minute, make sure you're doing it right. You are allowed to make your decisions for those folks on specialized, their specialized experience for the work, their capacity and their capability, their past record of performance, and their proximity and familiarity with the project. Those are all elements that were actually very similar to the ones that were brought up in that Cat versus Belton case that I talked about previously. Section 8.291, it's actually subsection 5, provides a local government opt-out provision if you have a commensurate local ordinance on selection of these professional services. This statute was actually, I think most recently revised in 2007, basically, and it tightened down. Like before, if you did your local opt-out, you could kind of, bend the rules quite a bit. But in 2007, the General Assembly kind of closed that loophole, and they really kind of married it back up to what the statute requires anyway. But after an amendment, the city's ordinance must be qualification based and commensurate with state policy. So you just have to make sure that you run a check on that to make sure your ordinances with respect to professional services bidding has been covered. All right, let's talk about some project delivery methods. Design build is a fairly new provision in Missouri law since about 2016. So we're going about 5 years. So prior to 2016, when my clients would come to me and say, can we do design build? I would say, ooh, I'm not so sure, especially if it was a 3rd or 4th class city. Okay, if it was a home rule city, there, it was a real good chance that they were going to be able to do that, right? And I assume that you guys have maybe covered already the different types of government, maybe earlier today. Okay, so you're used to that part. Okay, so, and the reason that I said, hey, I'm not sure you can do that is exactly what we just talked about in the 2 slides before, right? Because if you're looking for design professionals, architects or engineers, there's a special statutory requirement for that. You've got to go through a certain process. That process doesn't say anything about selecting a design professional with a contractor, and design build oftentimes marries up design contract with a price. Okay, so why would we want to do design build? Why do people even look to do it? It's this reason. If you've ever been involved in any sort of a big project where you've got a designer and someone who separately constructs it, what inevitably happens is, the contractors out there trying to, make these, put these 2 boards together or whatever. And they're like, that idiot designer, they have no idea. They don't live in a practical world, and you can't make this happen, and blah, blah, blah. And they'll tell you that it can't be done the way the designer, the architect or the engineer drew it up. And then you call up the architect or engineer and you tell them, this guy says you're a complete clown. You can't get this thing figured out, whatever. And then, then the designer is like, that's ridiculous. You absolutely can do this. And then what ends up happening is they just sit there pointing at each other, and you're just in the middle saying, just build my project already, right? So the reason that we try to look to design build is you marry up the team from the beginning, okay? So pre-2016, we didn't know if 3rd or 4th class cities could do that. Now we do, thanks to two statutes that kind of that have appeared to authorize this at that time. Okay, so talking about these two statutes, we have 67, 50, 60. So chapter 67, subsection 50, 60, and then 67, 50, 70. These were the ones that were brought in 2016 in two different bills. So I'm going to take just a second here. Hopefully it's been plugged to you already. If not, I'm going to plug it again. If you are not using MML's website and using the one-stop shop feature that is on that, you are completely missing out. Okay, so make a note if you haven't already, if somebody hasn't told you this, on MML's website, they have a tab for one-stop shop. But when you click on it, it's got just dozens and dozens of resources for different municipal law topic or municipal issues. And then when you click on it, they have everything from legal analysis to forms to sample ordinances to you name it. And I'm pointing this out because actually when this law came out in 2016, our firm wrote an article about this that kind of explains this whole, everything that we're going to go over in this slide. And, so if you're thinking about design build at any point, highly recommend go out and grab that article because it's kind of helpful from that standpoint. I'll summarize it here. So what I'll tell you is that 67, 50, 60 is designed for general public works projects, okay? Unfortunately, when you look at it, it requires this crazy long and drawn out process in order to pick a team and a design and a construction person at the same time, okay? There is a three-phase process. There is kind of, I think, risk to the city at each phase. And there's even a thing where if you've got somebody who's kind of going through the phase process, if you don't ultimately select them, you actually have to pay them money, which, to me doesn't make sense. No offense to any architects or engineers in here. That's who wrote the bill clearly because they really benefit from it. But I will tell you, actually, I don't love it, the design build side. So I kind of try to stay away from it. And I think if design build, the selection process was supposed to be easier than picking architects and engineers from what we learned in chapter 8, it didn't. It made it harder actually in that circumstance. So that's, kind of disappointing. Now, I talked about 67, 50, 60. At the same time, 67, 50, 70 was also adopted. This statute for design builds applies only to wastewater and water treatment projects, okay? Very specific type of public works. There's no rules in this one at all. It just says you can do it. So like as a lawyer, I'm kind of like, okay, well, that kind of scares me too, because, now if there's no rules, now I'm afraid that, when I get to court over an issue like that, the judge is going to be like, well, you can't believe really that there were no rules, right, Mr. Lauber? And the argument would be, yes, judge, in fact, I do, because in the very same year, they drafted this one over here that was all this detail. So clearly they meant for this to not be very detailed. So if you have a wastewater or water treatment project and you would like to use design build, I say go for it. Okay, you can do that. There's very not much in it. There is now statutory authority to do that. If you want to use design build for other general public works projects, you can do that too. Understand you're going to go through kind of an arduous process to get your design build team picked in the first place because the statute says so now, okay? Okay, another thing that was added in 2016 is what's called construction manager at risk. And this is another public works project delivery method. And essentially what I'll kind of tell you is for the most part, cities are pretty good at, resurfacing a road, doing a mill and overlay, maybe laying some sewer pipe or something like that. We're pretty good at that. But, on, bigger projects, it's really not our bailiwick. Okay. But, and then we also don't want to get in the situation where, we've had a design professional over here and we have a construction professional over here, and they start to argue and they're pointing their fingers each direction. So what a city can do is they can hire what's called a construction manager at risk. This is covered at 67.5050. And the construction manager at risk essentially is It's your agent that you can hire, and their responsibility is to work with, you tell them, Mr. or Ms. Construction Manager at Risk, we have a, City Hall project that we have got to get done, and it cannot exceed $1.5 million no matter what. Okay. And the construction manager at Risk says, okay, I've got it. So they will then work with whoever your design professional is to make sure that they're not putting in, crazy, marble, pillars and, the crown moldings and all that stuff that's going to jack your prices up. And, because design professionals, they're, very, artists, and they have, some really beautiful designs, but holy crap, when you try to put a, cash to that, it's a lot of money, right? So they help to, keep their expectations down, if you will, from the design side. And then once it flips over to the construction side, then they make sure that the contractors themselves are not, doing things that add costs and so forth. And that construction manager at risk part, what that means is if that project ends up over the 1.5 million, that construction manager is responsible for that. So they basically give you a bond, and they make up the difference. So they have a really vested interest in making sure that your project comes in on budget. Okay. So again, that is a delivery method that you can use, 67, 50, 50. So I just want to make you guys aware of that. Okay. So now we're going to talk about use of construction manager. I didn't say the at-risk part. Okay. Well, construction manager is authorized at 8.675 through 8.687 Missouri statutes. And this has been in place since 1995, right? So you would think that, I just said the construction manager at risk piece went in 2016. So clearly, the General Assembly is like, oh, and don't forget, you've got this construction manager piece over here in Chapter 8, and this is how these things flow together. Oh no, I don't even think the General Assembly saw it, even though courts will say that the General Assembly is charged with knowledge of all of their laws. So there is no mention if that construction manager at risk in any way affected this authority to do that. So just pointing it out to you, what the construction manager services are is you can hire somebody to assist you, kind of be your consultant, your liaison, to work with the design professionals and the construction professionals as you go through the process. I guess maybe the only difference that I can truly see is that whole at-risk piece of it, where, I guess you could hire these folks, and if the budget, it's over budget, it's like, too bad, so, I mean, I guess, it was all said and done. What I would tell you is if you want to go the construction manager route to help with your public works projects, I would use the new at-risk provisions, and I would probably just skip this stuff that's in Chapter 8. It's just an option for you anyway. So pointing them out to you. Okay, let's talk about some bonds. Okay, these are not the general obligation bonds to help you get money. These are actually protections for you. So the first kind of bond that we're going to talk about is a payment bond. So the first thing I will mention is if you've ever done any work on your own house, okay, if you had your roof redone, and what would happen if you didn't pay the roofer? Somebody's going to file a mechanics lien against you, right? And you're going to have cloud on your title until you get that contractor paid and you get that item resolved. So if you're, especially if you're re-roofing to sell your house and then they file that mechanics lien, good luck, they've got you at that point. We don't have mechanics liens on public works projects, okay? It's not okay for a roofer to put a mechanics lien on City Hall, okay? Just from a public policy standpoint, we can't have it. So what has happened is the General Assembly, because those mechanics liens are not available to contractors who work on public projects, they've created this payment bond requirement. And essentially what it is it says that if for any public works projects over $50,000, okay, I'm going to stop for just a second and say it again, over $50,000. So any of you that are back, kind of taking this as the second time around class, you may, if you were here prior to 2014, that number used to be different. So in 2014, or prior to 2014, you had to do these public works bonds on projects that were 25,000 or more. So now it's 50,000. So any project that is public works project that is $50,000 or more in value, you must get a payment bond, okay? I'm gonna catch your attention here for just a second. There is an absolute duty to require a payment bond on a project that is $50,000 or more, okay? So if you are an alderman, a council member, a mayor, a city administrator, and you're sitting in this room, if you don't require the $50,000 bond, you can be personally liable for that. Your house, your car, your kids' college tuition savings, they can come after you if you didn't require it, okay? Now, for those of you who are council members and board of aldermen members in the room, I'm gonna tell you that if your council or your board of aldermen has on the books an ordinance that says we absolutely require payment bonds on public work projects over $50,000 or more, you're now off the hook. That's a safe harbor if you have the ordinance that requires it. But for you mayors, chief executive officer of the city, or you city administrators, assistant chief executive officer of the city, that does not go away, because it is your responsibility to make sure that that payment bond is obtained. And so now, for those of you that are still freaking out about that, haven't run screaming out of the room and haven't resigned your office as a result of that, keep in mind that as long as you're acting within the scope of your authority, city insurance will typically cover you for omissions. Okay, and that's what that would be. Real quick, sir. So he asked a question about whether if you're working with an engineering company, would they require the bond? I'm not sure, sir. I don't know. What I would say is I would not leave that to someone else. You make sure as a city that you get that required, because if they miss it, that's not going to be their liability, it'll be yours. Okay. Part of the bid process, right? Okay, so let's move from payment bonds to performance bonds. So another type of bond, okay, wait, I guess I didn't really actually cover the real basic of what is a payment bond. So a payment bond, obviously based on the kind of the warm up for that was the idea that if for some reason the contractor, a subcontractor, or a material supplier on a job doesn't get paid for something, that there's a way for them to get paid. And that's what the payment bond did. So now we're going to talk about a performance bond. A performance bond is a bond that would make sure that the contract actually gets performed. Okay, there is nothing more useless than half a bridge. Think about that for a second. Okay, so you want to make sure that when you start a public works project, that your project gets done. And unfortunately, this year we did have kind of a rash. Maybe some of you here have dealt with this, where we had a contractor that was doing a lot of work for cities. The head person in charge of the contracting company caught COVID, and I don't think that he passed away, but he was in the hospital for a very long time and was very debilitated as a result. And they ended up having to close their company. And that left projects in several of our cities, I know, open. And we actually had to go after the performance bond in that circumstance. And we had to get the bonding company to actually go out and find a new contractor to come in and finish our projects for us. And that's what a performance bond does. Now, further back in history, back into the 90s or so, it used to say all public works projects, at that time 25,000, but now 50, right? $50,000 or more require both a payment and a performance bond. Okay, there was some weird edit in the statutes. Excuse me, weird edit in the statutes along the way, and they changed the and to an or. I don't think they meant it. They changed the word though. So what I will just tell you is, if you're getting a payment bond, get a performance bond too. And I'll go back to my original statement: is nothing so useless as half a bridge, right? So make sure your projects get done, and how you do that is through a performance bond. All right, maintenance bonds. Let's talk about that. So maintenance bonds are another type of bond that you can get on a project. And what I'll tell you is these are essentially kind of like a warranty. So definitely when you're going through the plat approval process and you're getting to the point where you're getting ready to accept dedication of the infrastructure that a developer has built, streets, sidewalks, water lines, sewer lines, those types of things, part of your, what your city inspectors are going to do is they're going to make sure that all of the infrastructure that was built according to the correct specifications for the city, right? Because at that point, that's, that developer is going to give that to the city and they're going to walk away. After that point, it's your responsibility as a city to plow those streets, to make sure your fire trucks can turn around in the cul-de-sac, to make sure that, those sewer lines don't break down in a year and a half. Okay. But what that maintenance bond can do is it'll say, before you accept it, you say, contractor, looks good. We think it's going to be fine, but we're going to make sure that it's going to be fine for at least 3 years. We're going to make you give us a maintenance bond that if something goes wrong, workmanship wise, or something like that in the next 3 years, that we can hit this bond and then have you either come back and fix it or somebody will have to come back and fix it. So not required, recommended, especially on larger projects that go a longer period of time. Okay, let's talk about Missouri Prevailing Wage Act. So there is a lot of stuff in public works contracts. Am I wrong? So, okay, so in 2018, the General Assembly completely redid the prevailing wage requirements for public works projects. So what I'll tell you is, if you have like complete insomnia and you want to go pull out chapter 290 and read through it some night just to help you out, you can take a look at that. There are 22 total sections in the Prevailing Wage Act in chapter 290. 18 of them were amended in 2018. So they were pretty thorough at that time. New sections were added, but they still kind of fit. Everything fits within 290, 210 to 290, 340 if you're looking for that. The purpose of the act is to create a reasonable wage rate for workers on public works projects. So the primary requirement is on the screen here, but essentially what it says is not less than the prevailing hourly rate of wages for work of a similar character in the locality for which the work is performed on public works contracts or the public works contracting minimum wage, which was an addition, shall be paid to all workmen employed by or on behalf of any public body. So what it essentially meant was you have to look at what wages are being paid in the area, and you have to be able to pay that minimum wage. And what it usually worked out to is, if you had an area that was subject to collective bargaining, so like a union contract, things like that, you were essentially going to be paying that union contract. What I will tell you is, though, the 2018 changes, made a lot of changes to that. And I mean, I don't have a dog in the fight as to, union, non-union, whatever. What I can tell you is, just from a practical standpoint, like I work in some very small communities, and we had communities, of maybe, like 600-700 people. And there was nobody coming out of the city to go do a project over there. And the local guy was willing to do it for, whatever he felt was enough to feed his family with, and didn't ask for, a lot more and like that. And it, like he didn't want to have to, pay that, because then he had problems with his own contractors after that. And it just got to a point where it was difficult. So just from a practical standpoint, I can tell you it has gotten a little bit easier with the result of that, because I don't have the problem, especially in my smaller towns where, people, there weren't anybody that were, coming to do that kind of the higher collective bargaining kind of rate. So just I guess a kind of like a anecdotal piece of that. So $75,000 is written in giant red letters up there. Okay. And the reason for that is that was a massive change to prevailing wage applicability in 2018. Prior to the changes in 2018, prevailing wages applied on any public works project where you hired a contractor, no matter what the price. Actually stood in a courtroom in the Western District of Missouri in Kansas City several years ago. I was representing the Missouri Municipal League as a amicus to the, and we had filed a brief. And I heard the state solicitor general argue that a contractor coming into City Hall and doing one stroke of a paintbrush on a door frame should be paid prevailing wage. And this was on a kind of a famous water tower case that we dealt with. And I thought, wow, it's like, I think most cities would say that's not new work. That's going to be, that's maintenance. And, and that day the court went with the municipal league, but ultimately the Supreme Court overturned it. So just keep in mind now, prevailing wage applies on projects that are $75,000 or more. One little note is if your project is projected to be, excuse me, say it's projected to be 70,000 and then it ends up being 80, prevailing wages will apply, but they will only apply for that part that goes from 75 to 80. So that $5,000. So they draw the line there. So I'm running quickly out of time. So who is covered? If you have your own public works employees doing the projects, prevailing wages does not apply. If you're bringing a contractor in, that does apply. Had a city very creatively one time said, we hired the public works department from the other city to come in and do our stuff, so we don't have to pay prevailing wage. And I was like, no, it doesn't work that way. They're still your contractor at that point. So they have to be your employee. Even if they're somebody else's employee, that doesn't work. Public works are all fixed works constructed for public use or benefit, paid for wholly in part or in part out of public funds. And the painting and decoration requirement in the definition is the one that was in play for the water tower case that we dealt with. So apologize, I'm going to speed up here real quick. Another addition in 2018 is now there are very specific holidays that have to be paid, and those are listed on the screen here and on your slides. You have to pay time and a half on any work over 10 hours a day and over 40 hours a week, and you have to allow 30-minute lunch breaks. Those were all new things that occurred. How the state determines the prevailing wage completely changed as well. That's the state's problem, not your problem. So I'm just letting you know that, they used to use the kind of like a mode method, and they would look at the number of union contracts, things like that. Now they take a look at, in your county, how many contracts are done by non-union, how many contracts are done by union. Whichever one wins, then they look at the average of the one that wins. And that's how they kind of determine it at this point. The locality, I kind of, said already, they kind of look to your county. And then they have a complete list of occupational titles that you kind of look at. Who has standing to complain? Actually, in 2018, they did change up who can complain about prevailing wage issues. Before, you might do a contract and award something, and then if the union shop didn't like it, they could sue you over it. That's not allowed to happen anymore. Now, an interested party so a decision-making public servant. So our elected officials can only complain on prevailing wage against contractors and subcontractors. Contractors can complain against subcontractors, and subcontractors can only complain against contractors, and then workers always have the right to complain. So a couple changes with respect to that. Real quick, I'm gonna hit prompt payment. If you ever want to not pay a contractor on something because you think they did a good job, be careful. There are very specific rules on that, so you should stop and ask your city attorney about that. I'm going to skip condemnation. Missouri laborers requirement. I was trying to get a few more of these in. The big red X is there. If you look in the state statutes, there's a section that says in times of high unemployment, you can only hire workers from states that are reciprocal with Missouri on hiring their workers. That statute is still there. You can go still look at it right now, but it was determined in 2012 that was unconstitutional. So don't follow that one. And one that you may be more familiar with was just last year, we had the Anti-Discrimination Against Israel Act that was passed in Missouri. So I know MML covered that in great detail. And that went into effect in August of last year. But what I will tell you is the 8th Circuit Court of Appeals, which covers Missouri, looked at an Arkansas case where an Arkansas statute says almost identically the same thing that Missouri's does, and they declared that one unconstitutional as well. So while I will tell you it wasn't a Missouri case, it was still the 8th Circuit. So at this point, I'm telling my clients, don't follow the the Anti-Discrimination Against Israel Act. Definitely don't make a decision about go or no go on that, because it's going to be unconstitutional as well, because that's the court we would go to once we got past our state federal courts, state-based federal court. There are immigration law requirements you have to be careful of. Primarily, participate in E-Verify. If you're hiring employees as a city, you have to do that. And if you're contracting with folks, they have to do it too. If your contract is worth $500 or more, you should be getting affidavits from your contracting partners that say, A, they participate in E-Verify, A, that they are enrolled in E-Verify, and that they actually actively use it, and B, that they do not hire any illegal aliens in their practice. There's a bunch of information on the Attorney General that's related to that, including some OSHA safety training rules you have to be aware of. And that's it. Sorry, I'm over, I'm sure. So, all right. Well, thank you for bearing through my awful coughing fit. I think I finally beat it. Appreciate your patience on that. Since I ran out of time, if you have any questions, I'll just be outside and can answer any of those. So that work, Chuck? Slowed me down, dang.
Coughing killed you.
God, that's bad. Luckily, it actually didn't.
Well, almost, yeah. Great, thank you. I actually timed his presentation. It was only 43 minutes. It was the extra 12 minutes of coughing that prolonged it, so. I'll be right with you just a minute. I got a wet wipe here. Nobody wants to ask questions. I wonder why. Holy cow, was that a lot of information? Okay, enough of that. Thank you, Joe. Well, we're going to take a short break and be back in the ballroom here at 4:45 for our round table discussion and networking session. So now you get a chance to talk with your friends and folks that you're sitting with. Join the MML Policy and Membership Associate Ramona Huckstep as she moderates this session and proposes scenarios focused on municipal issues. The group will then discuss solutions and share experiences. This is a great opportunity to learn from each other and communicate with other elected officials from municipalities throughout the state. After the roundtables, we will host a reception in the Parliament Room across the hall. See you at 4:45.